starting to get really interested with U.S. immigration. Can Donald Trump give you a green? Hey guys, before you file for your spouse, Hello, guys. Come on in. Welcome to today's Freedom Now show. As you're joining this broadcast, type in Freedom Now, which is what we go by at McBean Immigration TV. We believe in immigration freedom. So if you believe that as well, type in Freedom Now. I'm Latoya McBean Pompey, an immigration lawyer in New York, working with clients globally at McBean Law. Contact us today, guys, at 914-898-9488, or just go on our website at McBeanLaw.com to see who we are and how to contact us. Thank you guys so much for being with me. We have some important news that we're going to cover in today's show, and then I'm going to go right into your questions. And I have a real special video that I'd love to share with you guys. Some of you might have already seen it on TikTok. It's just such a good, heartwarming video that I'm sure will encourage you guys. And then lastly, we're going to end with some good news stories that you guys have shared with me. Throughout this broadcast, we'd love to be able to see what good news you have as well. If you've been approved for a green card or asylum or work permit or citizenship or any good news, maybe you've had an interview recently with immigration and it felt good to you. You walked away from that interview feeling really strong and confident, and you got your approval. Share those details below so that we can encourage others. Now, with that being said, guys, we're going to go right into our immigration news stories. All right, birthright citizenship. This is actually good news, okay, concerning birthright citizenship. As you guys know, there was a preliminary injunction that halted the enforcement of the executive order that President Trump signed in January, which sought to end birthright citizenship. And there was a preliminary injunction that the judge, let me back up, a preliminary injunction halting the enforcement of the executive order which sought to end birthright citizenship has officially taken effect. The Trump administration failed to appeal within the 7-day stay period, which now allows the injunction to proceed, which means that it's going to block the administration from moving forward with ending birthright citizenship. So this is actually very, very good news. Friday was the deadline. Last Friday was the deadline for the Trump administration to appeal the preliminary injunction order that the judge had issued, and they did not proceed with an appeal. And the U.S. District Judge had issued the preliminary injunction on July 10th in the Barbara v. Trump case, and the court certified a nationwide class of U.S.-born children who would be impacted by the executive order. This injunction comes just weeks after the Supreme Court limited the use of nationwide injunctions in a ruling tied to cases in Washington and New Jersey. Despite the ruling, the judge's certification of a nationwide plaintiff class provides a new legal pathway for blocking federal policies deemed unlawful. As reported by the New York Times, this tactic may now be the only remaining practical and efficient way for district courts to stop or halt executive actions on a nationwide scale or level. This is really significant, guys, really significant. This case marks a major challenge to Trump's efforts to redefine the 14th Amendment, which guarantees citizenship to nearly all individuals born on U.S. soil. The injunction protects the rights of U.S.-born children, many of whom have immigrant parents. It protects them from being stripped of their citizenship. Now, what's next? The Trump administration may pursue a full trial, But for now, birthright citizenship remains intact under federal protection. And the case sets a very important precedent with respect to how courts can navigate Supreme Court constraints while still providing nationwide relief. So this is huge. Obviously, things are unfolding minute by minute here with these big changes that President Trump is trying to enforce. But this is good news that they didn't think that they could win on appeal by appealing this preliminary injunction that the judge had put in place here to stop the administration from enforcing the birthright citizenship executive order that was signed in January. So this is going to play out in the court system, and I'll be sure to keep you guys updated. Next, friends, this is about Medicaid. Some of you might have already seen in the news that the U.S. Health Department handed over Medicaid personal data to ICE. Now, the U.S. Department of Health and Human Services, that's HHS, has authorized ICE to access the personal data of 79 million Medicaid enrollees. This move significantly expands the Trump administration's immigration policies into the healthcare space. The stated goal, friends, is to identify and remove individuals unlawfully who are potentially receiving Medicaid benefits. A DHS spokesperson confirmed this is part of an initiative to ensure only lawful residents receive federal health coverage. But this is obviously also another way of finding people, okay? Just another way to find people and get their information, such as their address and other personal data. HHS claims the data sharing agreement is legal and complies with all federal laws, including HIPAA. Privacy advocates, however, they argue that this move may violate HIPAA protections, especially if sensitive data like home addresses and ethnicities are being shared with ICE. This federal effort could certainly undermine these state programs and discourage enrollment among immigrant communities. And obviously, some of you will already know that some immigrants, their children maybe, in addition to themselves, I don't know, certainly, are receiving Medicaid benefits. And so this data, it's unclear what type of oversight will be provided as this information sharing is happening now between HHS and ICE. It's unclear who's actually going to look over this process to ensure that the data, that HIPAA laws are protected and covered, and that it's a limited intrusion into data sharing here. Congress, we know, have already, on the House Republican side and Senate Republican side, they have, for the most part, washed their hands of their oversight functions with respect to anything concerning the administration. So I don't have much faith that they're going to do anything here on the oversight side of things. We'll see if they will allow the House and Senate Democrats to make this a priority in various committee meetings. But this is something that I really think you guys need to be aware of. We already know that IRS data sharing is underway, and now HHS Health and Human Services data is also being shared with ICE. Next, friends, with respect to ICE, and this goes into the funding issue. ICE is now looking to use the $45 billion that Congress had allocated recently through the One Big Beautiful Bill. They are looking to expand and build more migrant tent camps, across the United States. U.S. races to build migrant tent camps after $45 billion funding boost, the Wall Street Journal has reported. ICE is preparing to expand detention capacity from 40,000 beds to 100,000 beds by the end of 2025. That's this year. That's this year, by the end of this year. The effort follows $45 billion in new funding allocated for immigration enforcement. ICE is building these large-scale tent camps across the country. Key sites include a 5,000-bed facility in Fort Bliss, Texas. Additional facilities are being planned in Colorado, Indiana, and of course, New Jersey. New Jersey, okay, is on the table here. Military bases and ICE-run jails are being prioritized over private prisons. So they are it's very similar to the setup in Florida with Alligator Alcatraz, which is their detention model. They're looking to set up more of those types of camps. It's faster to get these camps in place versus going down the road of private prisons and the time that it actually takes to build these prisons. So they're looking to use the $45 billion in that manner. Homeland Security Secretary Kristi Noem says the administration prefers to work with Republican-led states and local governments. Private prison companies are being sidelined in favor of state-run detention centers. Yes, friends. So we're going to see more of that, more of those white tents sprinkled about in Republican-led states across the United States. And then lastly, and this one has to do with some fees. You guys have heard me talk about the major increases in immigration fees through the One Big Beautiful bill, the act. It's now law. This is one fee that I think that you guys need to be aware of, and it's the $250 visa integrity fee. And this is on top of application fees that individuals need to pay as they're applying for their visa to come to the United States. All non-immigrant visa applicants to the U.S. will be required to pay a new visa integrity fee. The fee will be at least $250 on top of existing visa and Form I-94 fees. It cannot be waived. It cannot be waived regardless of your visa category. So who must pay this fee? It applies to all non-immigrant visa applicants like tourists, students, and business travelers. It does not apply to travelers from visa waiver program countries like Australia, Japan, and most of Europe. Now, can you be reimbursed, or is there any reimbursement policy that's attached to this? Well, apparently, visa holders may be eligible for a refund, but only if they don't overstay by more than 5 days and they don't violate visa conditions. For example, working here in the United States without authorization. Refunds will be processed after the visa expires, but there is no current system that's in place right now to handle reimbursements, and the process may take years to develop. We'll see how that goes. The fee is paid only if the visa is approved. The start date and payment process, as I've mentioned, are not finalized yet, particularly on the payment process inside of things. And the Department of Homeland Security and other agencies must coordinate before implementation begins. All right, guys, those are top immigration news that I thought you guys needed to hear about today. Now we're going to transition to your Q&As. Okay, so let's see. Thank you for being here. Again, guys, type in freedom now. Type in freedom now, and also put in your good news. Put in some good news stories here that we could share and celebrate with you. Thank you for being here. Let me go up just a little bit. Okay, someone is asking a question about the processing times for the I-130. So it depends certainly on the category as usual. Who filed for you? Which category are you in? If it's a marriage category, maybe an immediate relative filing, you're looking at maybe max up to 18 months, although a lot of cases these days under the Trump administration are moving very quickly, very, very quickly. We've just had a story. I think we testified about it. I'm not sure. I think it was like 2 or 3 months just recently. They're coming in like that quickly these days. But it depends on your category. For some people, it could take very much up to years in order to get an approval. Come on in. Let's see. Let me just go back up a little bit. Guys, we're asking that you do not spam. If you spam, we will place you in timeout. This session is being moderated. Thank you, guys. So please do not spam. Let's go down a little bit here. Okay, so my lawyer filed an asylum case for me when I was 17 years old. The lawyer told my mom my case was denied. 10 years later, I missed the appointment for the same case. Can I claim misrepresentation? So there's an asylum case. There was a lawyer on the file. Your case was denied. So according to the lawyer, you missed an appointment. Which appointment did you miss? Did you miss an interview, or did you miss a hearing in immigration court? Can I claim misrepresentation? I'm not sure where the misrepresentation part occurred in your story, JD. You may want to get a one-on-one private meeting with us to speak about what happened there, so that we could fill in some gaps here. But certainly, yeah, I'm not sure how to respond to that. Get an appointment so that we could drill down a little bit further, because I'd really like to know what the misrepresentation was in this case. Thank you guys for being here. Thank you, James. I see that. Let's go up a little bit. And I do see some great news about naturalization. We're going to grab those and be sure to share your news. Let's see, go up a little bit. Let's go up. Thank you. Okay, my process for adjustment of status is on step 4, case decision. This is taking longer. Leonardo is asking about his adjustment of status case. How long has it been pending? That I would need to know how long it's been pending to be able to really predict. Really, at this point, it would be a prediction how much longer you might have to wait for that case. If you are outside of processing times, contact the government, put in a service request, a couple of service requests, one per month for at least maybe 3 months. What if you're outside of that processing times? So you could take that step. You could also certainly speak with your congressman or congresswoman, their office, their congressional office, so that they could put in a request for you as well. Those congressional steps usually work. For many people, they do work. And then if none of those steps really work and you're still waiting, you could certainly reach out to us. We'd be happy to meet with you and see whether now is the time to move forward with the mandamus to sue the government to take on that next step in your case rather than having you wait. There are times, I will tell you, there are times when I tell people, and you said, those of you listening, you might have heard me say that to you one-on-one, that it's based on the facts of your case, and all, or maybe also based on the fact that we've studied your background and we've seen your records and we understand what's going on. There's a possibility that your case will be denied, so you've got to gear up for the next step. So therefore, we don't think it makes sense really to file a lawsuit to sue the government, because you're getting closer to that decision and it might very well be a denial. But not to worry, there is a way to continue to challenge it and move forward with the process, but maybe in a different way or a different strategy. So sometimes you need to have that discussion with an attorney, okay? Guys, thank you so much for being with me. If you're now joining, I covered 4 very important immigration news. You can watch the replay of this video after the broadcast. I'm going through the immigration Q&As at this time. All right, here's a good question. My wife sent in the I-92B because the I-130 was denied. because USCIS determined that my prior marriage was sham. What should we expect later on? So here you have an I-130 case, which is a spousal case. And although this individual is in a genuine bona fide marriage currently through his wife, they denied the U.S. citizen wife's case because they're alleging that her husband was part of a sham fake marriage just for the benefit of the green card. So they've blocked the wife, which is what they commonly do. They blocked her from getting her approval. She then appealed the decision, which is what this 290B petition is that they have pending. And so now they're waiting on a decision. So once the 290, the government might approve her request to reopen your case and give you a favorable outcome and approval. It could go in that direction, and I really hope that it does. Otherwise, the other way that it could go, of course, is they could deny it. And if you come to us at that point, certainly, or even before that, because we can work with you now, actually, in the state that you're in, just waiting on a decision on the 290B. But if you came to us and told us this story, presented us with these facts, our first step would be to request your records from immigration to get to see whether they had gotten it right or not regarding your prior marriage and figure out a way to defend you in this. Then we would want to do another filing of an I-130 case and try to build the evidence and make it stronger for you the second time around. Then we would also tell you in the beginning that you should expect a notice of intent to deny or a request for evidence, and certainly expect an interview from the government. And depending on what happens, if it's either annoyed, or RFE, or an interview, or a combination of those, we will respond for you and be there with you through till the end. And the end could very well be an approval of the I-130. And if they deny the case, then we would try to fight it again in a different manner for you. So right now, you could either wait and see, or you can maybe get a second opinion to see whether you should do a refiling of the I-130 case. Okay, and this is the type of case that we handle all the time at McBean Law. Let's see. Can you explain about the Dignity Act detail for U.S. citizen spouses? Yeah, so there is a very lengthy live session that I did last week, I believe, on the Dignity Act. I did a very deep dive for each section. So I'm asking my moderator to put in the link in the chat here for you so that you could just quickly go to that video and watch the breakdown that I did in that live session on the Dignity Act. One thing that I can think of that it does for spouses, for those who are married to U.S. citizens, is it has a section in there which is another legislation. The Dignity Act comprises of a couple of, maybe 3 or 4, maybe different immigration legislation that never went very far in Congress, one of which is, I think it's called the American Families United. I sometimes get it wrong with the title, so forgive me. You guys correct me all the time in the comments. Thank you for your help. But in any event, that could help some spouses of U.S. citizens. Why? It could help because it could help because it could help because if your immigrant spouse, if your immigrant spouse has a significant problem, like maybe the permanent bar or false claim or something very, very serious on his or her immigration record for which they can't overcome at this time under current existing immigration laws, well, they would be able to apply for a waiver, forgiveness, through the Dignity Act. If it passes, there's a very slim chance that it's going to go very far. But I'm talking about it. I've talked about it. Why? Because everyone else is talking about it on Capitol Hill, and you should be educated to know what's being discussed because it might impact you down the road. So that's one way. The other way is that there's pathway to citizenship in there also for dreamers and DACA holders. That's in there, okay? But go back and watch my deeper dive last week on this topic. All right. Type in freedom now, guys. Let's keep going with your immigration questions. Someone says, let's get the live. Please like up. the live. I like how you said that. Thank you for that, Ms. Campbell. Appreciate it. Okay, let's see. Let's go down. Freedom Now. The VAWA is taken still 3 years on the VAWA. I haven't heard any news regarding to them speeding up the VAWA cases. If you have a court date schedule, can ICE pick you up? If you have a court date schedule, can ICE pick you up? Yes, it's possible for some people that they would try to pick you up in court. There is a lot of that is happening these days in Manhattan. Okay, right here in New York, they're doing a lot of that. They're really targeting people whose immigration case has been dismissed right then and there on the spot by the judge in court, dismissed. Although it's possible that they could try to grab others whose case is not dismissed. I've heard lawyers, I've seen them in their videos saying things like, the case has not been dismissed yet or anything like that. It's still ongoing, yet that individual is still being taken in. But they are targeting folks whose immigration court hearing was dismissed on that very day by the judge. Then also they're looking for facts like, how did you enter? Did you come in through one of the Biden parole opportunities over the last couple of years or not? So they're looking for those details. Thirdly, obviously, if they know that you have a criminal record, they're looking for those individuals as well. You should try to get a WebEx hearing, try to get a hearing over the internet, an internet-based hearing. Many judges are very liberal on that. Many of them will just grant you the requests for that type of hearing so that you could sit in your lawyer's office and have your hearing, or sit at home in your living room and have that hearing. Try that. But there are other strategies that you can think about as you're preparing for your hearing that you should speak with an immigration lawyer about. Not saying that it's going to give you 100% protection, because it won't, because the ICE agents are being very aggressive. But for some people, they go in, they are detained and release. They're doing more. They have been doing more on the releasing side recently because of space capacity issues, but they will not be doing very many of that going forward as they're building these tents across the US, as I've just shared with you. They're going to just put up these fast tents all across the US, and they will have enough beds to house people. And then there is a very big change that they've made to their policy about bonds, which for some reason I thought I did a deeper dive on that topic, but apparently I didn't do a deeper dive on the bond issue. That I might have done a reel about it, in which they're saying now that they are not going to release individuals if they detain you. They're not going to let you out on bond. They're not going to approve those bond requests, regardless of whether you had been here for a year or 5 years or longer. It just doesn't matter to them anymore, based on a BIA decision that came down a little while ago. So they're getting tougher with the releasing aspect of things. So you want to make sure that you have a good case even before you get into immigration court. Before you show up, you've got to know what you're trying to do, what your approach is, okay? Freedom Now, guys. Is it safe to file an I-130 and an I-601 today? Bun Bun is asking. Bun Bun, we're still filing those. We're still filing those. We're still getting approvals on those kinds of waivers, the 601. It's get your case looked at firstly, thoroughly. Share your full record with your attorney if you work with one, and have that attorney be tough in his or her approach as they analyze your facts, and tell you, be straight with you, very direct with you. This is a bad record that you have. They are likely to try to set you up for a potential arrests based on this bad record that they will really treat in a very harsh way, set you up for the worst. And for many people, it doesn't get that far, right? But at least you know what to do, and you can prepare yourself and prepare your family in the event the worst case scenario happens. For others, your 601, that fraud, that misrepresentation will be treated in the normal course of things. They're not going to arrest you. You'll be fine. You'll go in, you'll get your case approved. That's what's happening for most people, okay? But for some individuals with the worst of the worst records, they are looking to detain you. All right, so be prepared for that and be prepared to fight a removal case. What is the processing time for unmarried child over 21? It's several years. You're looking at maybe 7 to 8 years, something like that. If, if the child is already overseas, if they're here in the US and they'll need another waiver, you're looking at maybe 10 years to process that case and travel overseas. Thank you, guys. Let's lighten up the live. Let's light it up, as someone said earlier. Let's see. Give me some hearts and likes. Thank you for being here. All right. Hi there, Ibrahim. Thank you for being here from Atlanta. I see you. Thank you. Thank you. Let's see. I received an intent. I received a notice of intent to deny a previous approval 2 years ago. I get InfoPass every year. I'm going to get it this year with current administration. Will I get it this year? So I'm going to try to, Mehdi, I'm going to try to see if I understand what you're saying here. You received a notice of intent to deny an approval that of your case that you had gotten 2 years ago. So maybe an intent to revoke an approved case. You said something about you're going in each year for an InfoPass appointment, and you're wondering whether you're going to get an InfoPass. They're still giving out InfoPass appointments. I would say that I would really love to speak more with you to learn a little bit more about what's going on with that notice of intent, because of course you only get a very short 30 days to respond to it. We would want to see what you're talking about there, what happened, and whether you should be going back into immigration for an InfoPass appointment or not. All right, so we'd be happy to talk with you on this level. My daughter has gotten her 10-year green card this year. When will she be able to file a petition for me? She'll be able to file once she becomes a U.S. citizen. For some people, it's 3 years after becoming a resident. For others, everyone else, it's 5 years. It just depends on whether how she got her green card. Was it through marriage or was it through a different way? Or was it through VAWA, right? Those are that's what determines things. Let's go down a little bit. Freedom Now, good to see you guys. Thank you for being here. Is it safe to file an adjustment of status case if I'm married to a U.S. citizen? I've overstayed my tourist visa. Yes, it is. Yes. I see some testimonials. Thank you guys for putting in your good news stories. Let's encourage each other with your good news stories. Thank you. And I'm going to pull up a couple of them shortly at the end of today's show. I'd like to know, what does it mean 11 months before case decision? Because I filed for my wife as a U.S. citizen. You filed for your wife. The case is pending. I'm not sure which app you're using, what's giving you that detail regarding 11 months or even how it's framed. I don't look at any of the apps, guys, not even the USCIS ones. I'm not sure how they're framing these things to you as they provide you with your updates. But an I-130 case, as I've mentioned, on average these days could very well be 18 months, even in a marriage case context, okay? Someone says that I am a J1 teacher here in the United States from Cameroon. I also have a pending asylum case. I was recently selected for the diversity visa program. Please, I need legal advice about how to go about it. It's very tricky because here's the thing. You're here in the U.S. Lawfully as a J1, you're in status, but you also had applied for asylum, which says that you can't go back to your home country because if you were to leave, you would literally be facing, you'd be committing fraud. And if you go back, you'd be persecuted. And that's what you've told the government, right? Through your asylum filing. And so therefore, if you do go back for this interview, you'd be committing fraud. So the other way of tackling this potentially is to try to get an appointment for an interview in a third country, in another country. What I don't know though is I don't recall, not that I don't know, is Cameroon. Cameroon, I think, is on one of the travel ban lists, right? Guys, correct, let me know. Let me know. Yes, yes, it is. I think I remember seeing Cameroon's name and mention in Cameroon several weeks ago when we were talking about the travel ban. And it applies to nationals, right? The nationals. So, for instance, if you're being interviewed in a country that's not a travel ban country, yet you're a national that is on that travel ban list, well, that's where the problem is. They won't issue that immigrant visa in light of that. But I don't remember the particulars about the travel ban at this time with regard to Cameroon. All right. Let's keep going. Let me see if I could tackle another question. Is it possible to removal in absentia order? Yes, it is possible, Rose, and we've done that for some clients. It's very difficult to do. It's through a motion to rescind it, to rescind that in absentia removal order, and once it's filed, it stops temporarily the deportation process, meaning that ICE cannot deport you during the time that the court is considering this in absentia, this request to rescind the order. So it is possible to get it done. It's hard to do, but it can be done. You should certainly work with an immigration attorney on this. All right, let's see. One more question before we go. I have a lot of consultations this afternoon, so that's why I have to get through this one very efficiently today. Let's see. Yes. Okay. Can a U.S. citizen child file a petition to the parent? I'm not sure about how I'm doing on the timing here. I'm a little, let's see. Okay, I'm going to be wrapping up. This is my last question, okay? Can a U.S. citizen child file a petition to for the parent, and the parent can use the 245I? So now the 245, yes, the 245I might be applicable in this case if I don't know what was the parent petitioned for before April 30th, 2001 by an employer, an old employer. You have maybe that parent has a perm application that was approved, a labor certification application that was approved, or I-140 petition. I don't know, or maybe another relative had filed for the parent back then. As long as so that's the question. Did the parent meet that cutoff? Then the second issue is, well, how did the parent enter the United States? I suspect that you're connecting your case to 245I because maybe your parent entered without inspection, right? If that's the case, 245I makes a whole lot of sense, but I don't know if your parent meets the qualifications for the 245I. Guys, I'm gonna share a really heartwarming video that just put a huge smile on my face every time I watch it. I hope that it will do the same for you. Okay. Hey, babe. Check your phone.
What happened?
Check your phone.
Hey, my love. Check my phone.
Check the text message I sent you.
I don't have anything.
No? You sure?
I don't have any messages.
For me?
Oh, apenas. No way. Oh. Oh.
Oh my God, there's nothing like getting that approval, right? Particularly if you need a waiver, right? Getting that waiver approval after years of waiting, there is nothing like it. So excited for that individual. And it's nice that, these families are capturing these moments on TikTok so that we could see what's happening with them. And with that, we're going to end with a couple of your stories, your good news stories. Again, thank you guys for sharing your good news stories. If you have not yet shared a story, share it now so that we could take a look after the broadcast and be able to share it the next time that I'm live with you guys on a Monday. So let's look at some of your stories. All right, Sokol says, we just had our marriage green card interview today in California. He has overstayed by 5 years, legal entry in 2019. Also had issues with his divorce. I applied April 16th and it was approved today, July 9th. I was shocked, no marriage questions at all. Such a relief. Sokol Ryan 7 says, congratulations. Sharon says she spoke with one of our attorneys and that attorney gave her the assurance she needed. She says, I did my N400 interview on July 14th and I passed my oath ceremony in 2 weeks. Thanks be to God. My appointment was for 10:15. I went in about 10:20 and was out a few minutes before 10:30, not even 10 minutes. And she goes on to say, I was very scared to go for my N400 interview, but I overcame the fear and I passed the interview. My immigration officer was very nice and made me feel very comfortable. I was sworn in on July 12th, and it was one of the most happiest moments of my life. I had a petty theft charge and it was dismissed. I went and got a copy of that charge. I took it with me to the interview and I gave it to the officer and he thanked me for being prepared, and just be honest going forward, guys. And lastly, Samantha says that she was approved for asylum, which is so hard to do, but she did it. So congratulations to you, Samantha, and your family. Guys, this was wonderful. Be sure to continue to share your good news stories with us. And I'm learning to read it out loud faster. I'm like, give me more time on the slide, please. This was wonderful. Thank you so much for being with me again here at McBean Law. We're here for you. We're reachable. You can reach out to us for an appointment. We'd be happy to meet with you guys. Contact us at 914-898-9488 or go to info@mcbeanlaw.com or email us at info@mcbeanlaw.com. And certainly you could see us online at mcbeanlaw.com where you could request an appointment with us. We're here for you. Thank you so much. And follow me on social media so that you'll be in the loop going forward for the rest of the week as I go live on TikTok, Instagram, and Facebook again. Guys, have a great rest of your day, and I will see you in the next one. Bye-bye.